Hello and welcome to the Attacking the Pleadings section of the ULV Justice Center website. Glad to have you. The information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise that you consult with an attorney. At this point in the case, the complaint has been filed and served by the plaintiff, and the defendant now has the choice to either answer the plaintiff's complaint or attack the pleadings. Before attacking the pleadings, the defendant should consider that the plaintiff is typically allowed to make amendments to their complaint if it is found to contain defects, and every trip to court is expensive. Attacking the pleadings in most circumstances is considered making an appearance in the lawsuit, in which case the defendant submits to the jurisdiction of the court. Attacking the pleadings will allow the defendant to narrow and clarify the issues of the plaintiff's argument. The complaint states what issues are in dispute. By narrowing the issues, only evidence that is considered to be relevant to those issues is considered to be under the scope of discovery and allowed into trial. A successful attack of the pleadings may result in the cause of action being dismissed completely. Attacking the complaint may be required if it contains information irrelevant to the cause of action. It is important to thoroughly comb through the complaint for defects. If the defects are not attacked early on, the defendant risks waiving their right to object to these defects later on in trial. Once the attack is filed, there will be a hearing for a judge to determine if the attack will be granted. There are a few different ways to attack the pleadings. A motion to quash can be used in a few different ways. A motion to quash service of summons is used when the service of the complaint was improper, which would render it to be void. This could be because the service of the complaint was done in an unauthorized way. The motion to quash may also be filed if the location is improper. This means that the court selected by the plaintiff lacks personal jurisdiction over the defendant, such as the defendant having a connection to California. When filing a motion to quash, the defendant is considered to have made a special appearance. If the court agrees with the motion, the case will be dismissed. If the court rejects the motion, the defendant must then respond to the complaint in 15 days. Once the defendant discovers that there are defects in the complaint served on them that do not meet the criteria for a motion to quash, a meet and confer meeting must be scheduled and take place at least 5 days before the response to the pleadings is due, which is 25 days after the defendant is served the complaint. The attack will be filed with the court after the meet and confer completed with the opposing party was unsuccessful to resolve the issues. A motion to strike will ask the court to strike, which means disregard or remove, portions of the pleadings. These portions may include words, sentences, paragraphs, and possibly an entire cause of action. The defendant asks for these portions to be removed because they are false, irrelevant, or improper. These may be things like a personal tax statement made by the plaintiff about the defendant's character or personality. It can also include contradictory statements and improper claims for damages. A motion to strike is considered a general appearance by the defendant. A demur is used to test legal sufficiency of the plaintiff's cause of action and their complaint. The demur does not challenge the truthfulness of facts alleged in the pleadings. Think of a demur as saying, "So what?" Basically stating that even if everything pled is true, the complaint is legally defective. This can be because the statute of limitations has run on this action or there are missing elements of a cause of action. These motions may result in dismissing the cause of action completely if they are used correctly. Demurs are also considered a general appearance by the defendant. There are two types of demurs. A general demur is used to say that the court lacks subject matter jurisdiction. This may be because the complaint fails to state facts sufficient to create a valid cause of action, or the case was filed in the wrong court. If the defect in the complaint can be fixed, the plaintiff will be granted leave of court to amend their complaint. If the defect cannot be fixed, the case will be dismissed. A special demur is used to assert that the pleadings have technical issues. These issues may be that the plaintiff failed to state the capacity of the parties, there is another action pending in another court for this cause of action, this case is one of defective joinder, there are uncertainties in the allegations, or in contractual dispute cases, the plaintiff failed to allege that the contract was oral or written. Whichever motion the defendant feels is appropriate for the defect needs to be filed within the same time that they have to respond to the complaint, which is 30 days. The court will provide the defendant a date for a hearing that will be no later than 35 days after the motion was filed. The opposing party must be notified at least 21 days prior to the hearing date. If the court sustains the motion to attack the complaint, the opposing party will be granted leave of court to amend their complaint, usually 10 days. The amended complaint may also be attacked if it contains defects. If it cannot be properly amended, the court will dismiss the complaint. If the court overrules the motion, the defendant will have 10 days to file an answer. If the defendant chooses not to attack the pleadings or there are no defects, they must file the answer to the complaint 30 days after service. All issues and facts pled in the complaint will be open for the opposing counsel to use discovery methods to obtain evidence. If the defendant does not answer or attack the pleadings, they will enter into a default judgment against them based on the facts alleged in the plaintiff's complaint. This has been an overview of the Attacking the Pleadings section of law. On behalf of the ULV Justice Center, we thank you for your time and hope that this information has been helpful to you in your legal matter.